claims back to 1840. The Treaty of Waitangi Act was amended, with the Waitangi Tribunal having its powers extended to allow investigation of Crown actions and omissions that could be in breach of treaty principles dating back to 1840. There were unexpected implications of going back to 1840, opening up the whole history of the terms and modes of colonization. Researching claims has proved an enormous and specialized task, given the paucity of pre-existing historical work and the level of detail required. The presentation of the claims to the tribunal, and subsequent settlement negotiations with the Crown, has also necessitated the involvement of many lawyers and other experts on behalf of both the Crown and the claimants. 1985 Waitangi Tribunal issues reports. An enlarged Waitangi Tribunal issued reports on treaty claims, often on a regional basis. More than 30 reports have now been issued, among them the Gay Report, Feet Rio Mori Report, the Taranaki Report, Kapapa Tuatahi, the Gaitahu Report, the Muirwenua Lands Report, the Wanganui River Report and T. Wanganui Atarami 6 hectares Taku. The Report on the Wellington District. 1986 Treaty Principles in Legislation. The State-Owned Enterprises Act was a key piece of legislation to incorporate a reference to the treaty. Since then, more than 40 statutes have referred, with varying degrees of emphasis, to the principles of the treaty in relation to the purpose of the legislation. Treaty principles are the core concepts that underpin both the Maori and English texts of the treaty. They reflect the intention of the treaty as a whole. From this the courts have been able to determine whether the principles are being appropriately applied. This has given the treaty far-reaching recognition in national and local government. Supported by a Waitangi Tribunal report on Te Reo Mori, the Maori language has also gained greater authority and usage. 1987 Landmark Court Case. A Landmark Court of Appeal case, Maori Council v. Attorney General, established that the Crown must pay heed to previous Maori ownership and disposal of surplus Crown assets such as land. This followed the breakup of old land-holding departments, and the establishment of new state-owned enterprises under the 1986 State-Owned Enterprises Act. That act declared that the Crown might do nothing that is inconsistent with the principles of the Treaty of Waitangi. The court set out a number of principles it saw encapsulated in or derived from the treaty. Perhaps the key principle was that of partnership, since the treaty had been signed by two partners. Another was that the Crown, as the more powerful partner, has a duty of active protection of the interests of the weaker partner, Maori. 1990 The CEST was centenary in the mid-1980s. In response to rising protests, the official role in celebrating 6 February at Waitangi had been minimized, and in 1988, it was suspended altogether. For the sesquicentennial year since the treaty signing, official participation returned to Waitangi. Public focus and awareness was on issues surrounding ownership and control of Maori resources as well as partnership between the Tangata Wenua, Maori, and Ngata Tiriti, Ge, the people of the treaty. 1992 Treaty Settlements signed. A comprehensive treaty settlement on commercial fisheries was signed, vesting $170 million with the Waitangi Fisheries Commission, to enable it to buy 50% of Sealord Products Limited, a large, Nelson-based fishing company. But the allocation of the fishery resource and proceeds caused much disagreement among Maori, particularly between coastal and inland tribes, traditional iwi and newer urban authorities, and the allocation issue was only resolved in 2004, with the passage of the Maori Fisheries Act. Major settlements were subsequently signed with Tainui in 1995 and Gaitabu in 1998, each at an estimated total value of $170 million. 1993 Te Tua Wenua Maori enacted after a great deal of discussion, led largely by the New Zealand Maori Council, a completely new act regulating Maori land was passed. Under Te Tua Wenua Maori it is now very difficult to purchase remaining Maori land. The Act also seeks to overcome the problems of fragmentation of titles among multiple owners, by providing for various kinds of trust under which the land can be managed. 1995 Rising protest on land and treaty issues. A series of protests in the mid-1990s denoted a new phase of activism on land and treaty issues. Many were generated in response to the government's proposal to limit the monetary value of treaty settlements to $1 billion over 10 years, the so-called fiscal envelope. A series of We around the country graphically illustrated the breadth and depth of Maori rejection of such a limitation in advance of the extent of claims being fully known, and much of the policy package, especially the fiscal cap, was subsequently dropped. These protests included occupation of Wanganui's Mautoa Gardens, twice, and the Takahue School in Northland, leading to its destruction by fire. Symbolic acts included attacking Victorian statue the America's Cup and the Lone Pine on One Tree Hill, and removing a Colin McCahan painting, subsequently returned, from the Lake Wikaramona Visitor Center. Rising protests at the Waitangi Day celebrations led the government to move the official observance to Government House in Wellington. 1995 Office of Treaty Settlements, established. The Office of Treaty Settlements, OTS, was formed from the previous Treaty of Waitangi Policy Unit, TOPU. OTS conducts negotiations with Maori claimants on levels of remedy for past breaches of the Treaty of Waitangi. Treaty breaches need to be proven, but not necessarily through a Waitangi tribunal hearing. The Treaty of Waitangi is New Zealand's founding document. Over 500 Maori chiefs and representatives of the British Crown signed the treaty in 1840. Like all treaties, it is an exchange of promises. The promises that were exchanged in 1840 were the basis on which the British Crown acquired New Zealand. The Treaty of Waitangi agreed the terms on which New Zealand would become a British colony. This is one of a series of booklets on the Treaty of Waitangi which are drawn from the Treaty of Waitangi Information Program's website www.treatyofwaitangi.gov.nz. Many historians have contributed to the material in these booklets to ensure it is as accurate and balanced as possible. Their contribution is gratefully acknowledged. Further copies of this booklet are available from the Treaty of Waitangi Information Program, State Services Commission, P.O. Box 329, Wellington, New Zealand. Copyright State Services Commission 2004. Permission of the owner and copyright holder must be obtained before any reuse of the images used in this booklet. Permission of the Alexander Turnbull Library, National Library of New Zealand, Te Punamatāranga o Aotearoa, must be obtained before any reuse of their images. Note: ATL equals Alexander Turnbull Library, National Library of New Zealand, Te Punamatāranga o Aotearoa. Archives equals Archives New Zealand, Te Ruamahara o Te Kawanatanga. ISBN 0-478-24474-6.